right, it's another Tuesday, and you know by this time it's always time for us to look at the administration of criminal justice law, breaking it down in ways that we can all understand it. Good afternoon to you. This is Wheel of Justice. My name is Ifeanyi Awa, and don't forget that this program is brought to you by the Abia State Administration of Criminal Justice Monitoring Committee and Prisoners Rehabilitation and Welfare Action Power, with the support of the Open Society Initiative for West Africa, OSIWA, and Abia State Justice Reform Team. Now, on previous occasions, we've talked about the issue of warrant of arrest, and we've had guests come in here to break it down so we can really understand what a warrant of arrest is and also how it works. Well, on today's edition of the program, we'll be looking at the issue, form, and service of summons under Part 15 of the Acjl 2017. Now, my guest for this Tuesday is His Worship Young Andrew Omenka. He is the presiding magistrate at Court 6, Osisioma Magisterial District. I want to say welcome to our studio.
Thank you.
All right. Now, we were having a bit of discussion earlier on about the issue of summons, and for some persons, they hear summons, they get to hear about warrants too, and then there seems to be a little confusion on how they both operate. But let's start off with what exactly is a summons.
Thank you. As a matter of fact, summons and warrant, as you mentioned, are means through which the courts brings a suspect to the courts to answer an accusation or allegation against him.
Mm-hmm.
So warrant, like you mentioned, is a directive or a direction by the magistrate or the judge given to a police officer to go to a particular person, a named person, and forcefully arrest him and forcefully bring him to the court to answer to the allegation made against him.
That's for warrant.
That is warrant.
Okay.
On the other hand, summons is equally a directive, a written directive directed to the person involved, not the police this time around, directed to the suspect whom complaints have been made against to come to the courts within a specified time. It's usually within 48 hours at a named location at a particular time to answer to the allegation or accusation made against him. The difference is the summons is given to the accused person
Directly.
Yes, directly. Whereas warrant of arrest is given to a police officer to forcefully bring him. If you may permit me to give you definition.
Yeah, go on.
Oh, thank you very much. The Osborne's Concise Law Dictionary, 9th edition, defines summons as a document formally issued from the office of a court of justice, calling upon the person to whom it is directed to attend before a judge or officer of the court. You understand? He is being called to come to the court. The other one is the police is directed to go and bring him.
Okay.
But it's worthy of note that by the time we go into the main discussion, it's not just the court does not actually beg. It is a directive, a strict directive, of which if he defaults or refuses to come, then a warrant of arrest may now be issued against him to forcefully bring him to court.
Okay. Now, I believe as we move on, we're going to also get to understand how this all operate. But let's start off with the issuance of a summons, because we're looking at the issuance and also the form and service of summons. So let's start off with it. When it comes to issuance of summons, how does it really work?
Okay. The issue in this regard is not issue of discussion, as some may want to understand. The context is given, issue, and then before a magistrate issues a summons or gives a summons, there must have been a complaint. If you are to understand this part of the Acjl, that is Administration of Criminal Justice Law of Abia State, 2017, you may have to recourse back to section 88 and 89. That is the section that deals with receiving of or making of complaint by a private person. If you feel that somebody has offended you or has committed any offense, you have to approach the court, either the magistrate or the officer of the court, that either the chief registrar, and then make oral complaint. It can be oral, you can make it a written complaint. You make, in this case, make oral complaint to the registrar or the magistrate that give the story. So person stole my Nokia touch phone on so date, and the value is this. Then the officer of the court will now put it down in writing. That is the complaint. Okay. That's the basis upon which the summons will now be made. And, okay. And now, after receiving this complaint, it is now left for the magistrate to determine if your complaint will warrant summons being given. If you take section 115.
Okay, sorry. Now, so as we move on, we get to understand this. Now, let me ask. Now, you're saying that a private individual goes to the magistrate to make a complaint, and then the magistrate issues a summon to the accused, actually. And does this mean that the private individual cannot go to the police, or when does the private individual go to the police and the police redirect this private individual to the magistrate?
Yes. As a matter of fact, a police officer, a private person can approach the police and make a complaint, just the same way you can make a complaint to the magistrate. If you make the complaint to the police officer will equally put it down in writing. That's take the gist of your complaint, and then now approach the court with a written complaint, upon which the court will now in turn give the summons or warrant, as the case may be. Okay,
now, being practical right now, we see in Nigeria where someone makes a report to the police obs up and goes to make an arrest. Is this proper? Is this the right way to go?
Yeah, the police act gives the police power to arrest anybody that is alleged to have committed any offense, and then investigate, and then bring the person to court. Even when complaints are made in court, before the court gives issue warrants, it's equally given to the police. Police is equally directed to investigate in the matter, because without proper investigation, there is no way the prosecutor will now have a basis upon which he can prosecute. There won't be enough evidence handy for him to prosecute. So the police must have investigate. So it's either the police gets direct complaint from the complainant and then approach the court, or the complainant go to the court direct.
Okay. Now, it's also very important to note that does the magistrate reserve the right to issue a summon, or is it every time an individual goes to the magistrate that he or she gets a summon?
If you look at section 113 of the Acjl, paragraph section 113 sub 1, or rather sub 1 paragraph A says that, if you may permit me to read.
Go on.
Now, it says that, subject to the provision of section 89 of this law, a person who believes from a reasonable or probable cause that an offense has been committed by another person whose appearance a magistrate has power to compel, may make a complaint of the commission of the offense to a magistrate, who shall consider the allegation of the complaint, and may, paragraph A, and may, in his discretion, refuse to issue a process, and shall record his reason for refusing. So if the magistrate feels that the complaint is nothing has happened, in fact you are just trying to raise dust, the magistrate can refuse to issue a warrant or summon, and then he will put it, give his reasoning in writing. Now, paragraph B says the magistrate, after the complaint is made to him, may issue a summons or warrant as he shall deem fit to compel the attendance of the defendant before a magistrate court in the district. So, in this regard, if he feels that there's a prima facie case, there's well, that's the term we use. That means something has happened. Somebody has been offended. That's prima facie case. Then he will issue the warrant or the summons so that the person come and clarify himself and to find out if he's actually guilty of the act which he's accused of.
Okay, now if you're just tuning in, this is Wheel of Justice, and you know it comes your way every Tuesday from 3:30 p.m. And it is brought to you by the Abia State Administration of Criminal Justice Monitoring Committee and Prisoners Rehabilitation and Welfare Action Power, with the support of the Open Society Initiative for West Africa, OSIWA, and the Abia State Justice Reform Team. I was speaking with His Worship Young Andrew Omenka, who is the presiding magistrate at Court 6, Musishama Magisterial District, and we've been looking at the issue, form, and service of summons under Part 15 of the Acjl 2017. That is the Administration of Criminal Justice Law 2017. Now, let's jump into this part where it states that a summons shall be served by a police officer or by any other officer of the court issuing it, or other public officer, or through a courier service company duly registered with the chief judge as a process service agent of the court under this law. So what he's saying is anyone can deliver a summons on behalf of the magistrate.
Well, it's not just anyone. Not that is you that's in the realm of service of summons.
Yes.
When the summons has already been made, I believe you are reading. Is it section 119?
Yes.
Section 119. A summons shall be served by a police officer or by an officer of the court. Look at the functional word there. Shall, must. A summons must be served by one, a police officer, or an officer of court. An officer of court, maybe the bailiff of the court, or through a courier service. Look at that. This thing, courier service duly registered with the chief judge. These ones recommended are the only people that can actually serve a summons, and not any other person. So the police officer, the bailiff of the court, or a courier company that is duly registered with the judiciary, in the case of Abia State, Abia State Judiciary, who received clearance or approval by the chief judge, and no other person.
Are there implications if some other person other than this mentioned serves the summons?
I didn't get.
Are there implications? Can if other than these persons that have been mentioned?
Yes.
If someone else who is not registered to the magistrate to the court delivers a summons, can the accused who is accepting taking the summons, or who is this summons is meant for, refuse to accept the summons?
Yes. You see, summons, service of summons is at the very a core issue in criminal adjudication.
Okay.
Criminal process, in the sense that if where service of summons is recommended by the law, and then the recommendation of the law is not strictly followed, it goes to the root of jurisdiction. It goes to the root of jurisdiction of that process. If I can quote rightly, in the case of Dahiru Muhammad against Taju, 1995, 5 of Nigerian Weekly Law Report, where it was held that where a service of process is recommended and then it is not followed as recommended by the law, anything done under that process becomes a nullity. That means if the laws recommend that a bailiff of court or a police officer serves a process, and then you don't follow that, and another person that is not recommended by the law
does it,
or you give it to the complainant's lawyer to go and drop, then that is not proper service. And once it is not proper service, everything you do within that process becomes a nullity. You cannot actually, if you convict the accused person based on that service, it can be set aside for improper service, provided it is established that injustice has been done on the accused person.
Okay, because of time, because we're running out of time very fast, let's jump into some other parts of this law. In terms of if the person effecting service of summons, does the summons have to be delivered personally to the accused?
Yes, it is recommended by the law. If you look at the section 120 of the law, it provides that summons must be served in the case of a human, that is a human person, because it's not only one person that natural person. When you talk of person, as a matter of fact, there are natural person and artificial persons. Artificial persons are body corporates, like a registered limited liability company. It's an artificial person. Summons can be made against it. A local government council is an artificial person, a corporation. But in the case of human person, he must be served personally. And if he is not served personally, it's improper service. Unless by leave of court, if you approach the court and seek the leave of court for an order to serve the person by substituted means, that is to say, if the court gives you the order, the leave, they allows you to serve by that substituted means, you can go to the person's house and text, or even advertise on a newspaper. Yeah, that is substituted service.
Sorry. Does this come under where the service where someone cannot be found?
That is exactly where you go for substituted service. When all the if I can get that, the law provides that when you have made all due diligence effort to serve and you fail, maybe the person is evading service, or the person cannot be located there. You only know his last place of abode. Maybe after the offense has been committed, you can approach the court, and the court will grant you leave to serve him. You can even serve him at a public place. That is, paste that document within the court premises if the court allows that, and it is deemed, if the court gives you the order and you effect the service as directed by the court, it is deemed as proper service, and then the matter can go on.
So if someone cannot be found, there are alternative ways of serving this summons. Now, what if where the person who is accused is a public officer? What does the law say about this?
The law provides, the law provides, we are still in section 120. It provides that if the person whom the summons have been made against is a public officer, the serving officer from the court can give it to the head of department of that office where the person works. It can be served on the head of department, so that he will now in turn give it to direct that process to the person, the accused person this time around. And then, but the most important thing is that the person effecting the service must file an affidavit, to show how he actually effected the service. There has to be an affidavit, and that affidavit is admissible in evidence in that judicial process.
Now from now on, we're going to try to really jump very fast so we can cover a lot of ground before the end of the program. Now let's look at where service of someone has to do with a place that is outside of the jurisdiction of the court. What happens in such a case?
That is, if I can remember, section 123 of the Acjl. Jurisdiction in this sense, magisterial districts or magistrates court. Abia State Magistrate Court is just a Abia State Magistrate Court. This one speculates where you have to serve the summons outside Abia State Magistrate Court. Like now, somebody commits an offense and he is in Imo State. You can't just make out the summons in Abia State and go looking for him in Imo State and serve him. You must have to look for the nearest court
in Imo State.
In Imo State, where that person resides, and go to that magistrate court in Imo State with a duplicate copy of that process, and then the court in Imo State will stamp it. It is called resealing. Reseal. Seal as in when you put a seal on something. Mm-hmm. The court in Imo State will reseal that process, and then it becomes effective to be served on the person, and then he can now be brought to Abia State.
Okay, now I know when serving a summon, there needs to be proof that this summon was actually served, and I think sometimes there needs to be a serving officer.
Yes.
So in a case where the serving officer is not available, what happens in such a case?
Yes. There are sometimes that a serving officer may effect a service, but before the matter commences, he may no longer be found or may no longer be alive. That is the essence of when a process is served on an accused person, someone. Mm-hmm. It is expected that you endorse a duplicate copy of that process at the back. Endorsement, that is, you sign your signature, you write your name, date. That endorsement suffices, because the serving officer ought to file an affidavit of service. But in this case, he is not around to file the affidavit. That endorsement on a duplicate copy becomes what proves to the court that this process was actually served, so that the court can go ahead to look into the matter. The court will not be hamstrung because the bailiff or the serving officer can no longer be found.
Okay. Yeah. Now, also, this law does state that when someone is served to a person, now the person whom it is addressed to has to sign at the back of the of it,
yes,
to show that he or she received,
to
acknowledge
yes,
that it has been received, the summons has been received. Now, in a case where this person refuses to sign, what happens?
Well, that is section 128. That's section 128 of the Acjl. If you are served, you are expected to sign, acknowledge that you have, because it's a directive from the court.
Yeah.
And then if you refuse to acknowledge, that person serving you has the power. The court gives him the power to arrest and detain you, and then bring you to court for contempt of court. If you may permit me to read section 128 of the Acjl, it says, where the court is satisfied that the suspect has been served with summons, and the suspect does not appear at the time and place appointed in. I hope for. No, that is not what I had in mind.
Okay. Okay, now,
but I'm just trying to, maybe I can't lay my hand on that particular section, but the law provides that the serving officer can arrest the person and detain him and then bring him to court for refusing to acknowledge this thing. Okay, oh, that is section 126.
Okay, now just because of time, we just got 1 minute to round off right now. We have just a minute to round off.
How time flies.
Yes, very fast. Now, when someone is disobeyed,
okay,
what happens next?
When someone is disobeyed, that's a disobedience to the court. The disobedience to the court is an insult to the court.
Okay,
and when a court is insulted, the court has the right and the power to order for the person's arrest. So if you disobey, if you refuse to attend court when someone, that is where I said it initially, that section 128, the court will now make out a warrant of arrest against the person, and then the person will now be brought to court to answer. That is where I was reading. That was why I got confused along the line. The court will now give order for the person to be brought to the court forcefully. That is after arresting, and then the person is brought to the court to answer the query.
Oh, I really wish we had time to come, because there's still other areas we would want to look at, and we have persons calling already, but I'm just going to take one call, and then we'll get to hear. Hello.
Hello.
Yeah, good afternoon. What's your name and where are you calling from quickly?
All
right, quickly, what's your question, please?
Okay. I don't know this number. I wanted
We can't hear you. Sorry. Okay, I'm sorry. Because of time, we can't really make out what he is saying. But I'm hoping we can look at this some other time. But I want to say thank you very much for coming through. This is His Worship Young Andrew Omenka. He is the presiding magistrate at Court 6, Usioma Magisterial District, and we'll be looking at the issue, force, and service of summons under Part 15 of the Acjl 2017. I have to stop right here. Don't forget, Will of Justice comes your way every Tuesday from 3:30 p.m. It is brought to you by the Abia State Administration of Criminal Justice Monitoring Committee and Prisoners Rehabilitation and Welfare Action Power, with the support of the Open Society Initiative for West Africa, OCWA, and the Abia State Justice Reform Team. My name remains Ifeanyi Awa. Please do have a wonderful day ahead. Coming up next is the Flow Ride with Venus. Stay tuned.
Thank you very much.